Before we begin, a quick and important disclaimer. The historical trends, legal frameworks, and case studies discussed throughout this presentation are intended strictly for educational and entertainment purposes. The American legal system, particularly regarding family law, asset division, and marital dissolution, is extraordinarily complex and highly localized. Laws vary dramatically from state to state and are subject to continuous legislative changes and judicial interpretations. Nothing presented in this deep dive constitutes professional legal advice, financial counsel, or a substitute for a comprehensive consultation with a licensed attorney in your specific jurisdiction. The historical narratives, potential outcomes, and systemic shifts explored here reflect past events and the evolution of legal practice, not a definitive guide to navigating modern legal disputes. If you are currently facing a separation, a custody dispute, or complex asset division, it is imperative that you conduct your own due diligence and retain qualified legal representation tailored to your unique, individual circumstances. Never use historical precedent or educational documentaries as a manual for your personal legal strategy. Imagine a system so structurally rigid, so morally unforgiving, and so legally suffocating that the only way to escape a broken marriage was to hire an attorney to orchestrate a meticulously staged, highly illegal act of theatrical perjury. You might believe that the cutthroat, multi-billion-dollar divorce industry of today, with its forensic accountants, aggressive litigators, and bitter custody battles, is a modern tragedy. But the truth is far more complex and significantly darker. The modern American divorce lawyer did not simply emerge from the halls of prestigious law schools. Their profession was forged in the shadowy underbelly of early 20th century legal loopholes, clandestine hotel room raids, and a systemic culture of manufactured evidence. The history of the divorce lawyer in America is not just a timeline of changing laws. It is a century-long masterclass in human psychology, legal manipulation, and the relentless pursuit of freedom at any financial or moral cost. To understand the legal battlefield of today, we have to uncover the buried secrets of the lawyers who built the arena. Consider the reality of a failing marriage in a state like New York in the 1920s. During this era, the legal threshold for dissolving a marital union was virtually insurmountable for the average citizen. In many jurisdictions, the absolute and only legally recognized ground for divorce was proven adultery. Incompatibility, emotional cruelty, and even severe physical abuse were simply not enough to satisfy the conservative statutory requirements of the time. This draconian legal environment created a desperate demand, and where there is desperate demand, an entirely new breed of legal professional rises to supply the solution. The early 20th century divorce lawyer operating in these strict jurisdictions was often less of a traditional legal scholar and more of a theatrical director and clandestine fixer. Because actual adultery was difficult to prove and socially catastrophic to admit openly without control, attorneys facilitated a booming underground industry of staged infidelity. A husband, wishing to grant his wife a divorce, would hire a lawyer who would then employ a specialized cast of characters. The attorney would arrange for the husband to check into a predetermined, cheap hotel room with a hired woman, known in the industry as a professional correspondent. These women were paid to wear revealing clothing and wait for the precise moment when a photographer and a private detective, also hired by the attorney, would burst through the door. Photographs were taken, affidavits were swiftly signed, and the meticulously manufactured evidence of adultery was brought before a judge. Everyone in the courtroom, from the stenographer to the judge presiding over the bench, often understood that the entire scenario was a fabricated performance. Yet, because the paperwork met the technical statutory requirements, the divorce was granted. The lawyer was the architect of this necessary perjury, a necessary evil in a society whose laws completely ignored the realities of human relationships. But this sordid, humiliating process was completely unpalatable to the American elite, the wealthy industrialists and high society figures who demanded discretion alongside their freedom. This demographic required a different kind of legal architect, which leads us to the birth of the divorce capital of the world, and the creation of the most lucrative legal monopoly of the early 20th century. Reno, Nevada. While East Coast lawyers were staging cheap hotel raids, the legal minds of Nevada recognized an unprecedented economic opportunity. They lobbied for and established incredibly permissive residency requirements. By the early 1930s, a person only needed to reside in Nevada for a mere 6 weeks to be considered a legal resident, at which point they could file for divorce on the incredibly vague and easily proven grounds of extreme mental cruelty. This legislative masterstroke transformed the Nevada divorce lawyer into a highly sought-after commodity. The attorneys in Reno did not just handle paperwork, they built an entire economic ecosystem. Wealthy unhappy spouses boarded the specialized trains from the East Coast, colloquially known as the Divorce Express, and arrived in Nevada where their specialized attorneys were waiting. These lawyers facilitated stays at luxurious dude ranches where their clients would ride horses, gamble, and wait out their 6-week residency requirement in high style. The lawyer was the concierge to freedom, managing not just the local judges but the public relations of the wealthy elite. They pioneered the concept of the migratory divorce, establishing legal precedents regarding jurisdiction and state sovereignty that would ultimately force the Supreme Court of the United States to weigh in on whether one state had to respect the divorce decrees of another. Yet, there is a massive open loop in this historical timeline. How did we transition from these underground fixers in New York and the dude ranch concierges of Nevada to the fierce, corporate, high-stakes family law litigators of the modern era? The answer lies in the dramatic cultural revolutions of the 1970s, the advent of the no-fault divorce, and the sudden realization that when you no longer have to fight over who is to blame for the end of the marriage, the fight shifts entirely to a much more complex battlefield: the complete financial destruction and reconstruction of the marital estate. This deep dive masterclass is designed to solve a very specific, deeply urgent problem for the American audience today. Most individuals enter into the legal process of marriage and potentially divorce, completely blind to the foundational mechanics of the system they are stepping into. You might think your attorney is simply there to file paperwork and argue your side, but you are engaging with a profession that has spent over 100 years perfecting the art of leverage, negotiation, and psychological warfare. By examining the century-long evolution of the divorce lawyer, we are going to decode the exact playbook used in modern family law. We will uncover how the strategies used to divide a simple family farm in 1945 evolved into the aggressive forensic accounting tactics used to untangle cryptocurrency, international offshore trusts, and complex stock portfolios today. This is not merely a recounting of historical dates and long-dead legal figures. This is a comprehensive step-by-step dissection of the legal mind. You will learn how historical trends have shaped the potential outcomes of modern alimony disputes, how case studies from the 1980s directly influence how child custody is weaponized in courtrooms right now, and why the billing structures of family law attorneys are designed the way they are. By understanding where the divorce lawyer came from, the tactics they had to invent to survive in a hostile legal environment, and how they capitalized on every single shift in American family dynamics, you will gain an unprecedented strategic advantage in understanding the legal machinery of marriage and its dissolution. You will learn to see past the intimidating legal jargon and recognize the historical patterns of strategy, leverage, and power that dictate the most financially and emotionally vulnerable moments of a person's life. To truly grasp the magnitude of this psychological warfare, we must step out of the shadows of the staged hotel raids and into the bright, unforgiving fluorescent lights of the post-World War II American courtroom. This was the era of the fault-based divorce, a legal framework so adversarial that it fundamentally shaped the DNA of the modern trial lawyer. In the 1940s and 1950s, the legal system operated on a strict binary of morality. There was an innocent spouse and there was a guilty spouse. There was no middle ground, no mutual parting of ways, and certainly no irreconcilable differences. To legally sever a marriage, an attorney had to publicly prove that one party had committed a specific, legally recognized sin against the marriage. This wasn't just about ending a relationship. It was a state-sanctioned moral execution. Imagine if a couple living today in 2026, let us call them David and Amanda, decided their marriage was simply no longer working. In 2026, they could file joint paperwork, divide their digital assets, split their retirement accounts, and quietly go their separate ways. But if David and Amanda were forced to navigate the legal reality of 1952, their mutual dissatisfaction would mean absolutely nothing to a judge. To get a divorce, David's lawyer would have to legally destroy Amanda, or Amanda's lawyer would have to systematically ruin David. The stakes were absolute. The spouse found guilty of the marital fault, whether it was adultery, extreme physical cruelty, or desertion, often lost everything. They could be completely stripped of alimony, denied custody of their children, and cast out of polite society. This extreme winner-takes-all environment created a terrifying incentive structure. It birthed a specific type of legal practitioner known anecdotally as the bomber lawyer. The bomber did not negotiate. The bomber destroyed. Their primary objective was not equitable division, but total annihilation of the opposing party's character. To achieve this, the divorce lawyer became intimately intertwined with another booming mid-century profession, the private investigator. A typical divorce proceeding was a massive, expensive intelligence-gathering operation. Let us break down the exact step-by-step process of how an attorney manufactured a fault-based victory during this era. First, the client would retain the attorney, who would immediately dispatch a team of private eyes. These investigators would shadow the opposing spouse for weeks or even months. They tapped landline telephones, a practice operating in a vast legal gray area at the time. They bribed hotel clerks for guest ledgers. They interviewed disgruntled former employees, nosy neighbors, and spurned acquaintances. The goal was to find a single thread of impropriety and pull until the entire fabric of the opposing spouse's reputation unraveled. Once the intelligence was gathered, the attorney would construct the narrative. This was not a presentation of dry financial facts. It was a highly emotional, meticulously scripted theatrical performance designed to shock the conscience of the court. When the trial commenced, the courtroom became a public theater of humiliation. Because court records were public, local newspapers often reported on the scandalous details of high-profile local divorces. The lawyer would call the private investigators to the stand to testify about late-night rendezvous. They would present grainy black-and-white photographs of the accused spouse entering a tavern with an unknown companion. They would force witnesses to recount shouting matches overheard through thin apartment walls. The historical trends from the post-war period show a massive spike in these vicious legal battles. In 1946, the United States saw a dramatic surge in divorce rates as soldiers returned from overseas and rushed marriages dissolved. The legal system was suddenly flooded, and the attorneys who mastered this ruthless, evidence-gathering warfare became incredibly powerful and wealthy figures within their local municipalities. They held the secrets of the town's elite in their filing cabinets. The leverage they possessed was astronomical. If a wealthy local business owner knew his wife's attorney had photographic evidence of an illicit affair, that business owner would surrender almost any financial asset demanded just to keep those photographs out of the public record. The threat of the fault-based public trial was often more powerful than the trial itself. It was an era defined by extortionate leverage dressed up as legal procedure. Furthermore, this brutal system inherently disadvantaged those without the financial means to hire these elite legal bombers and their army of private eyes. A working-class spouse trapped in an abusive marriage often had no way to gather the necessary legal proof to satisfy the stringent requirements of extreme cruelty. They could not afford the private investigators, the expert witnesses, or the aggressive legal representation required to win a fault-based battle. The law was technically equal, but the application of the law was entirely dependent on capital. The divorce lawyer was a luxury item that functioned as a gatekeeper to personal liberty. Consider the potential outcomes for a woman in this era, who failed to prove her husband's fault. If her attorney could not meet the evidentiary burden, the judge would simply deny the divorce petition. The couple would remain legally bound. The wife would be forced to return to the hostile home environment, now with the added animosity of a failed public legal attack hanging over their heads. The system trapped people in domestic war zones, and the lawyers were the only heavily armed mercenaries available for hire. By the late 1960s, the societal pressure against this archaic, destructive legal framework reached a boiling point. The public was exhausted by the manufactured perjury, the extortionate settlements, and the public humiliation required simply to end a broken partnership. The legal profession itself began to fracture, with progressive attorneys arguing that the court system should not be in the business of assigning moral blame to intimate human relationships. The stage was being set for the most profound legal earthquake in the history of American family law. A legislative shift that would completely wipe out the bomber lawyer's traditional playbook overnight and force the entire industry to evolve or face extinction. But when the dust settled on this revolutionary legal change, the new breed of attorneys realized that removing moral fault did not end the war. It merely shifted the battlefield from the bedroom directly into the bank account, and the tactics they were about to develop would make the private eyes of the 1950s look like absolute amateurs. The year was 1969. The state was California, and the legislative pen that signed the death warrant for the old, fault-based system was wielded by Governor Ronald Reagan. By signing the Family Law Act, California became the very first state in the nation to enact a true no-fault divorce law. What did this monumental shift actually mean in practice? It meant that for the first time in American legal history, a spouse could walk into a courthouse and declare irreconcilable differences. No definitive proof of adultery was required. No meticulously manufactured evidence of extreme cruelty had to be presented. No private investigators were needed to lurk outside cheap motel rooms taking grainy photographs. The marital contract was simply over because one person unequivocally stated that it was over. Historical trends indicate that this legislative innovation spread like a wildfire across the country throughout the 1970s and 1980s, fundamentally rewriting the statutes of nearly every jurisdiction. But if you harbor the misconception that this legislative simplification made the aggressive divorce lawyer obsolete, you fundamentally misunderstand the economics of separation and the adaptable nature of the legal profession. The elite attorneys did not disappear. They strategically mutated. When the newly reformed laws stripped away the powerful weapon of assigning moral fault, these attorneys immediately began searching for a new mechanism of leverage. They found this leverage buried deep within the marital estate. If a lawyer could no longer legally punish an opposing spouse for being unfaithful or cruel, they would pivot and punish them by forensically dissecting every single dollar they had ever earned, spent, or attempted to hide. The traditional divorce lawyer traded the fedora-wearing private investigator for a far more lethal and sophisticated companion, the forensic accountant. Let us break down the exact step-by-step mechanics of how this new era of financial warfare operated on the ground. In the old fault-based system, the dramatic courtroom trial was everything. It was the main event. In the new no-fault system, the trial was merely the exhausting finale of a much longer war. The true battle was now fought in a grueling pre-trial phase legally known as discovery. Discovery is the formal mandatory legal process where each side is compelled under penalty of perjury to reveal their complete financial holdings. In the 1970s and 1980s, as inflation skyrocketed and the American middle class began to accumulate increasingly complex assets like specialized pensions, diversified stock options, and expansive real estate portfolios, the discovery process morphed into an intricate, weaponized maze. Imagine if our hypothetical 2026 couple, David and Amanda, are navigating a high-asset separation today. Amanda strongly suspects David is actively hiding significant wealth in anonymous cryptocurrency offshore cold storage wallets. Her modern legal team will routinely subpoena specialized blockchain analytics firms and demand digital access logs to trace those decentralized funds. But back in the 1970s, hiding assets was a strictly analog, paper-based game of cat and mouse. Husbands, who traditionally controlled the majority of household finances during this specific historical era, would routinely transfer lucrative property titles to anonymous shell corporations managed by their golf buddies. They would aggressively siphon cash from their small businesses and bury it in obscure safe deposit boxes under assumed names in neighboring states. Some would even deliberately crash the valuation of their own successful companies right before officially filing for divorce, intentionally making the business appear absolutely worthless on paper, so they would not be forced to split the equity with their soon-to-be ex-wife. To combat this, the divorce lawyer of the 1970s had to become an elite financial bloodhound. They learned to read complex corporate tax returns like a treasure map. They systematically subpoenaed decades of bank records, relentlessly tracked down those hidden safety deposit boxes, and aggressively deposed business partners under oath in hostile conference rooms. This required a completely different, highly analytical skill set compared to the emotional courtroom theatrics of the past decades. The potential outcomes of a divorce settlement were no longer dictated by who possessed the most scandalous photographs, but strictly by who had hired the most ruthless, meticulous financial team. This era also coincided directly with a massive, unprecedented cultural shift. Women entering the professional workforce in record numbers. The traditional outdated alimony model, where the husband simply paid a set monthly amount to support the wife indefinitely, began to fracture under the weight of this new economic reality. Lawyers immediately realized that the legal definition of marital property was rapidly expanding, and they pushed the boundaries aggressively. They began litigating complex questions. Was a specialized medical degree earned during the marriage, financially supported by a working spouse, considered a divisible financial asset? Was a future corporate pension, not yet accessible or vested, something that could be legally split today? The attorneys pushed the boundaries of these definitions in appellate courts, creating entirely new bodies of complex case law that dictate modern asset division. Let us examine how a typical aggressive financial discovery strategy unfolds, a blueprint pioneered in this exact era that remains the gold standard today. Step 1 involves the initial, overwhelming document demand. A lawyer will serve a massive request for production, demanding 5 to 10 years of comprehensive tax returns, business ledgers, bank statements, credit card bills, and investment portfolios. If the opposing side intentionally stalls or provides incomplete, redacted records, the strategy escalates to step 2, the formal deposition. The lawyer forces the opposing spouse into a small room, places them under oath with a court reporter present, and cross-examines their personal spending habits line by meticulous line. They will demand to know exactly why there was a $5,000 cash withdrawal in October of last year. They will demand the identity of the secondary name on an obscure corporate checking account. The immense psychological pressure applied during these financial interrogations is specifically designed to force crucial mistakes and uncover hidden wealth. Step 3 is the deployment of the specialized forensic accountant, who will painstakingly reconstruct the entire lifestyle of the marriage to mathematically prove that the reported income simply does not match the actual, real-world spending. If a spouse confidently claims on their tax returns that they only make $50,000 a year, but the forensic accountant proves through bank records that the couple consistently spends $10,000 a month on exclusive country club dues and luxury car leases, the lawyer has successfully cornered them in a lie. The leverage is instantly recaptured. This intense, granular financial scrutiny completely transformed the American divorce from a moral judgment into a highly lucrative, specialized corporate industry. Because the assets being bitterly fought over were becoming larger and exponentially more complex, the legal fees skyrocketed in tandem. Billable hours became the undeniable lifeblood of the modern family law firm. An attorney was financially incentivized to leave absolutely no stone unturned, because every turned stone, every drafted subpoena, and every hour spent reviewing bank ledgers meant another hour billed directly to the client's retainer. This created a highly paradoxical situation where warring couples could easily spend a quarter of their total combined net worth simply paying the various legal professionals hired to divide it. The no-fault revolution, originally intended by lawmakers to make breakups cleaner, faster, and less destructive, inadvertently built a multi-billion-dollar legal machine that thrived on financial complexity and procedural exhaustion. By the late 1980s, this sprawling financial battleground was fully established and heavily fortified. The complex strategies of asset tracing, business valuation, and forensic accounting were standardized across the legal profession. But as the money grew, so did the bitter resentment between the divorcing parties. And the top-tier attorneys quickly realized that financial ruin was not the absolute only way to destroy an opponent. They discovered an asset far more valuable, far more emotionally volatile, and far more susceptible to deep psychological manipulation than any stock portfolio or commercial real estate holding. They realized that if you truly wanted to break someone, if you wanted to guarantee their complete, unconditional surrender in a high-stakes financial negotiation, you do not just go after their money. You go after the one thing they literally cannot live without, and the legal system was about to give these lawyers the perfect, devastating weapon to do exactly that. That devastating weapon was child custody. For decades, the legal framework surrounding the children of divorcing parents was relatively straightforward, heavily relying on a legal presumption known as the tender years doctrine. Under this historical precedent, the family court system operated on the inherent, almost automatic assumption that mothers were the natural and best-suited caregivers for young children. Unless a mother was proven in open court to be profoundly unfit, severely negligent, or dangerously unstable, she was virtually assured primary custody. Fathers were typically granted minimal visitation, perhaps every other weekend, in order to pay child support. Because the outcome was so heavily predetermined by this gendered legal doctrine, there was actually very little room for aggressive litigation regarding the children. But as the feminist movements of the 1970s successfully pushed for gender equality under the law, the tender years doctrine was systematically dismantled across the United States. In its place, state legislatures adopted a new gender-neutral legal standard that sounds incredibly noble on paper, but became a weapon of mass destruction in practice: the best interests of the child standard. To a layman, prioritizing the best interests of a child seems like the only moral way to handle a family fracture. But to a highly skilled, ruthless divorce lawyer, the phrase best interests is a goldmine because it is entirely subjective. There is no mathematical formula or objective historical trend that defines what those best interests actually are. Is it in the child's best interest to live in the larger house with the parent who works 80 hours a week but provides elite private schooling? Or is it in the child's best interest to live in a modest apartment with the parent who earns less but is home every afternoon to help with homework? Because the law suddenly provided absolutely no definitive answer, the question had to be litigated. And where there is subjective litigation, there is an opportunity to manufacture unprecedented leverage. Imagine if we look at a highly contested separation playing out right now in the year 2026. A married couple, let us call them Michael and Sarah, are locked in a bitter dispute. Michael is a high-earning tech executive with millions of dollars in unvested stock options, while Sarah sacrificed her own career for a decade to raise their 3 young children. Michael desperately wants to protect his stock options from being divided in the final financial settlement. Under the old system, he would have no leverage. But under the modern subjective custody system, Michael's aggressive legal team can execute a brutally effective flanking maneuver. They advise Michael to file for full, sole physical and legal custody of the children. They do not do this because Michael actually wants to be a full-time solo parent. They do this entirely to terrify Sarah. The psychological warfare of this strategy is absolute. When a parent, particularly a primary caregiver, is suddenly faced with a massive, formal legal petition threatening to take away their children, they enter a state of sheer, unadulterated panic. The financial fight over the marital estate immediately becomes secondary. The stock options, the retirement accounts, the equity in the family home, none of it matters anymore compared to the survival instinct of keeping their kids. The lawyer has successfully shifted the battleground from a spreadsheet to the deepest emotional vulnerability of the human psyche. Sarah's legal team now has to divert massive resources, tens of thousands of dollars in retainer fees, just to defend her fundamental right to mother her own children. This is the exact moment Michael's lawyer will quietly approach Sarah's lawyer in the hallway of the courthouse and offer a settlement. They will propose that Michael will generously drop his aggressive bid for full custody, allowing Sarah to keep the children, but only if Sarah agrees to sign away her legal right to his unvested tech stock. Faced with the terrifying potential outcome of losing her children to a subjective judge, Sarah capitulates. The children were never the actual target. They were the tactical leverage used to extort a highly favorable financial surrender. To facilitate this complex, high-stakes extortion, the divorce lawyer had to construct an entirely new multi-million-dollar sub-industry within the family court system. If you are going to argue about the subjective best interests of a child, you need experts to validate your narrative. Enter the era of the child custody evaluator, the forensic psychologist, and the guardian ad litem. When a modern custody battle erupts, the lawyers will petition the judge to appoint these third-party professionals to investigate the family. The guardian ad litem is often another local attorney, appointed by the court but paid for directly by the divorcing parents at premium hourly rates, whose sole job is to represent the voice of the children. Forensic psychologists are hired to conduct exhaustive, invasive evaluations of both parents. These psychological evaluations are grueling, terrifying processes. Parents are forced to undergo extensive personality testing, such as the Minnesota Multiphasic Personality Inventory, answering hundreds of deeply personal questions designed to detect underlying psychopathology. The divorce lawyer's goal is to use these tests to formally diagnose the opposing spouse with a personality disorder, painting them in official court documents as a narcissist, borderline, or emotionally unstable. They will hire expert witnesses to analyze the interactions between the parent and the child through two-way mirrors, looking for microscopic signs of emotional detachment or inappropriate bonding. This era also saw the weaponization of deeply destructive psychological concepts, most notably the theory of parental alienation. Historical trends from the late 1980s through the 2000s show a massive spike in lawyers utilizing this specific accusation. If a child legitimately did not want to see one parent because that parent was harsh or emotionally distant, the lawyer for the rejected parent would aggressively claim that the other parent was systematically brainwashing the child. They would demand that the court rip the child away from the preferred parent to break the psychological conditioning. It created an incredibly toxic legal loop where a protective parent could be legally punished and lose custody simply because their child expressed a valid fear of the other spouse. The legal fees required to bring in dueling teams of highly credentialed psychological experts to argue over brainwashing theories were astronomical, routinely bankrupting both families while enriching the legal and psychological professionals involved. Even darker was the evolution of what became known in legal circles as the silver bullet strategy. As courts began to take allegations of domestic violence and child abuse more seriously, some cutthroat attorneys realized that a mere accusation, even without immediate hard proof, was enough to trigger catastrophic legal consequences for the accused. In high-conflict cases, a lawyer might subtly encourage a client to file an emergency ex parte protective order, claiming they fear for their safety or the safety of the children. Because judges operate out of an abundance of caution, These emergency orders are often granted immediately, without the accused spouse even being present to defend themselves. The accused spouse is instantly evicted from the family home, stripped of all access to their children, and permanently branded with a horrific public stigma. While the truth eventually comes out during a full evidentiary hearing months later, the tactical damage is already done. The accused spouse is exhausted, legally outmaneuvered, financially drained, and completely desperate to settle. This horrifying tactic not only destroys the opposing party, but creates devastating collateral damage for actual victims of domestic violence by making judges inherently skeptical of all abuse claims. By weaponizing the children, the modern divorce lawyer perfected the ultimate scorched earth campaign. They transformed the dissolution of a family into an apocalyptic, winner-takes-all blood sport that left generations of children traumatized and marital estates completely liquidated into legal fees. But as the sheer brutality and public spectacle of these highly publicized, toxic courtroom battles reached their peak at the dawn of the 21st century, the ultra-wealthy elite realized they had created a monster they could no longer control. They realized that exposing their deepest financial secrets and parenting failures in public courtrooms, subject to public record requests and tabloid scrutiny, was a catastrophic liability. They needed a way out. They needed a mechanism to buy their way out of the public justice system entirely, and the legal industry was more than happy to invent a completely unregulated, dark money shadow court to accommodate them. This shadow court system is formally known in the legal industry as alternative dispute resolution, encompassing the highly lucrative fields of private mediation and binding arbitration. To understand why this parallel universe of justice was created, we have to look at the collateral damage of the 1990s and early 2000s tabloid culture. During this era, high-profile divorces became front-page entertainment. Because the traditional family court system is a public forum funded by taxpayers, the filings, the bitter allegations, and most importantly, the forensic financial disclosures, were matters of public record. Any journalist with a legal pad could sit in the gallery, request the docket, and publish the exact net worth, spending habits, and psychological evaluations of a prominent CEO, a Hollywood celebrity, or an inherited billionaire. For the ultra-wealthy, the public court system was no longer just a venue for dispute resolution. It was an unacceptable corporate and personal liability. The elite divorce lawyers realized they needed to offer their most powerful clients an escape hatch. They lobbied for and utilized specific legislative loopholes that allowed disputing parties to entirely bypass the congested, public court dockets by essentially renting their own private justice system. This is how the modern rent-a-judge industry was born. Instead of waiting 2 years for a trial date in a crumbling municipal courthouse, wealthy spouses could mutually agree to hire a retired, highly respected former family court judge to preside over their case in private. Let us break down the step-by-step mechanics of how this shadow court operates. First, both spouses and their respective legal teams sign an extensive, ironclad confidentiality agreement. They agree to step out of the public system and legally bind themselves to the decisions of the private arbitrator. Next, they select the judge. These are not random mediators. These are often the most experienced former jurists in the state, individuals who have stepped down from the public bench specifically to enter this incredibly lucrative private sector, routinely charging anywhere from $1,000 to $3,000 per hour for their services. Instead of a public courtroom, the trial is held in a secure, mahogany-paneled conference room at a high-end law firm or a luxury hotel suite. There are no journalists. There are no curious onlookers. The court reporter is bound by strict non-disclosure agreements, and the final decree is sealed. Imagine a high-stakes separation occurring right now in the year 2026. A couple, let us call them Marcus and Chloe, are dissolving a 10-year marriage. Marcus is the founder of a highly successful artificial intelligence logistics company, preparing for a massive initial public offering, and Chloe owns a 30% stake in the enterprise. The entire marital estate is valued at roughly $800 million. If Marcus and Chloe were to litigate this in a public municipal court, Marcus's corporate rivals would immediately deploy paralegals to comb through the public discovery filings. They would gain unprecedented access to Marcus's proprietary algorithms, his internal corporate communications, and the exact valuation metrics of his upcoming stock offering. The public divorce would systematically destroy the company's competitive advantage. By utilizing the shadow court of private arbitration, Marcus and Chloe's lawyers eliminate this catastrophic business risk. The forensic accountants can aggressively debate the valuation of the artificial intelligence patents, and the lawyers can wage war over the division of international offshore trusts, all behind locked, soundproof doors. The historical trends of the last 2 decades show a massive migration of high-net-worth divorces into this private sector. But while it offers absolute discretion, this system introduces a terrifying, often unspoken legal peril: the complete surrender of the appellate safety net. In the public court system, if a sitting judge makes a fundamental error in applying the law or blatantly miscalculates the division of an asset, the losing attorney can file an appeal to a higher court to have the mistake corrected. The appellate courts exist specifically to police the trial courts. But in binding arbitration, you are effectively buying finality at the cost of oversight. If your privately rented judge makes a catastrophic mathematical error that costs you $50 million, the potential outcomes for overturning that decision are statistically abysmal. American courts are overwhelmed, and they overwhelmingly favor upholding private arbitration awards precisely to keep those complex cases off their own dockets. To overturn a private judge, a lawyer must usually prove outright, intentional fraud or extreme, documented bias, a legal threshold that is nearly impossible to meet. You are paying a premium for speed and silence, but you are walking a tightrope without a net. This evolution fundamentally changed the specific skill set required of the elite divorce lawyer. The screaming theatrical litigator of the 1980s was replaced by the sophisticated, corporate diplomat of the 2000s. The psychological warfare did not disappear. It simply grew quieter and vastly more expensive. In a private arbitration setting, the power dynamic is inherently skewed by capital. Because the private judge bills by the hour, the spouse with the most liquid cash can effectively starve out the opposing spouse by intentionally dragging out the private hearings, filing endless private motions, and forcing the less wealthy spouse to drain their retainer just to keep the private judge in the room. The lawyer became a master of financial attrition, using the high cost of the shadow court itself as a weapon of leverage to force a rapid, favorable settlement. What this century of practice ultimately built was a literal 2-tier justice system. The middle class, fighting over pensions, home equity, and child custody, is trapped in an underfunded, agonizingly slow public court system where their deepest personal traumas are officially recorded in the public ledger. Meanwhile, the power brokers, the tech billionaires, and the celebrities exist in a bespoke, frictionless legal universe where their sins, their assets, and their ultimate settlements are completely erased from the public consciousness. For a long time, this system functioned perfectly for the American elite. The assets were neatly categorized, hidden behind NDAs, and quietly divided. But society was about to undergo a technological revolution that the rent-a-judge system was entirely unprepared to handle. The very definition of a marital asset was about to violently shift. What happens to the legal playbook when the wealth is no longer tied to physical real estate, corporate stock, or hidden cash? What happens when a couple spends a decade building a multi-million-dollar, intensely personal digital empire together? How does a lawyer divide the value of an identity, a global audience, and a monetized personal brand? The history of the American divorce was about to enter the completely uncharted, wildly unregulated territory of the intellectual property separation. The arrival of the digital age and the creator economy fundamentally broke the traditional divorce lawyer's calculator. For nearly a century, the division of marital property was a relatively static exercise in accounting for tangible items: the suburban home, the 401k, the family station wagon, and perhaps a small business with a physical storefront. But as we move into the reality of 2026, the American divorce lawyer has been forced to become a high-stakes intellectual property litigator. We are now in the era of the intangible asset, where the most valuable property owned by a couple might be a YouTube channel with 10 million subscribers, a viral TikTok persona, or a library of digital courses. This presents a logistical nightmare for the legal system because, unlike a house, you cannot simply sell a personality and split the proceeds. Historical trends show that the legal system is currently scrambling to catch up with the concept of a person as a brand. Imagine if we look at a modern case study involving a couple named Tyler and Madison. Over their 7-year marriage, they built a massive lifestyle brand centered on their relationship. They filmed their wedding, their home renovations, and the births of their children. Their audience is emotionally invested in the union itself. In 2026, when Tyler and Madison decide to divorce, their lawyers are not just fighting over the house in Austin. They are fighting over the future revenue of a digital ghost. The first major hurdle in this new legal frontier is the valuation of the digital footprint. A traditional business valuation expert looks at past earnings, physical inventory, and market demand. But how do you value a social media account where the algorithm is a black box, and the revenue is tied to the physical face of only one spouse? If Madison is the face of the channel and the primary creative force, but Tyler handled all the editing, the brand deals, and the search engine optimization, who owns the equity? The lawyer must now hire specialized digital forensic analysts to perform a deep dive audit of every platform. They analyze engagement rates, churn, and historical trends in ad revenue. They use predictive modeling to estimate the potential outcomes of the brand's value if the couple stops appearing together. In many cases, the value of the brand drops by 70% the moment a divorce is announced because the audience feels betrayed. The divorce lawyer's job is to argue that their client deserves a payout based on the peak value of the brand, while the other side argues the brand is now a dead asset. Step by step, the lawyer executes a strategy known as the goodwill analysis. In legal terms, goodwill is the value of a business that exceeds its physical assets. There is professional goodwill, which is tied to a person's individual skill, and enterprise goodwill, which belongs to the business itself. In 2026, the battle is over whether a YouTube channel's success is professional goodwill belonging solely to the influencer, or enterprise goodwill that should be split 50-50. To win this, lawyers will subpoena years of behind-the-scenes communication. They will look at who signed the contracts with sponsors, who managed the lighting, and even who wrote the scripts for the viral videos. If the lawyer can prove that their client was the secret architect behind the influencer's fame, they can demand a massive buyout or a percentage of all future earnings from that channel for years to come. This has birthed the era of the digital alimony. In the past, alimony was designed to help a spouse maintain their lifestyle until they could become self-sufficient. In the world of intellectual property and digital brands, lawyers are now negotiating for a cut of the digital royalties. They are treating a social media handle like a songwriter treats a hit record. Even after the marriage is over, the lawyer may argue that because the spouse helped build the initial audience during the marriage, they are entitled to a percentage of every AdSense dollar and every brand deal for the next decade. This creates a permanent financial tether between two people who desperately want to be free of each other, turning the divorce decree into a long-term corporate licensing agreement. Furthermore, the divorce lawyer in 2026 has to deal with the terrifying power of the non-disparagement clause. In a traditional divorce, if you tell your friends that your ex-spouse was a nightmare, there are rarely legal consequences unless it rises to the level of defamation. But for a digital creator, a single negative post from an ex can trigger a massive cancellation, leading to the loss of millions in sponsorship deals. Attorneys now spend hundreds of hours drafting ironclad digital gag orders. These agreements specify exactly what can and cannot be said on social media, often including liquidated damages clauses where a single TikTok video disparaging the ex-husband could cost the wife $50,000 in immediate penalties. The lawyer has evolved into a brand manager, protecting the financial viability of the asset while simultaneously trying to dismantle the marriage. This leads to a fascinating and disturbing case study in the weaponization of data. Lawyers are now using sentiment analysis AI to prove that an ex-spouse is intentionally sabotaging a brand. If the analytics show that every time the ex-husband posts a specific type of content, the comments section becomes toxic toward the wife's brand, her lawyer can sue for tortious interference. We are seeing a shift where the divorce lawyer must understand metadata, community guidelines, and platform TOS, as well as they understand the family code. But as complex as the digital brand is, it pales in comparison to the next massive shift the American divorce lawyer had to face. For a century, the one thing a lawyer could always rely on was the stability of the US dollar and the transparency of the banking system. But as we moved into the mid-2020s, the emergence of decentralized finance and the metaverse created a trillion-dollar blind spot. Attorneys began to realize that their traditional forensic accountants were completely powerless against a spouse who had converted their entire liquid net worth into encrypted digital assets, virtual real estate, and anonymous privacy coins. Imagine a husband who, in the months leading up to a divorce filing, systematically moved $3 million into a series of cold storage wallets and decentralized liquidity pools. He walks into court and claims he is broke, providing bank statements that show a zero balance. In 2026, the divorce lawyer had to transform once again, becoming a cyber detective capable of navigating the dark web and the blockchain. The tools of the trade are no longer just subpoenas for bank records. They are specialized software designed to trace transactions through layers of digital obfuscation. The battle was no longer just about who got the house or the kids. It was about the very survival of the legal system's ability to find the money at all. And as the lawyers began to crack these digital vaults, They discovered that the money wasn't just being hidden in wallets. It was being laundered through virtual worlds in ways that made traditional money laundering look like child's play. The discovery of wealth hidden within the blockchain and the metaverse has forced the American divorce lawyer to undergo a radical technological transformation. We have moved past the era where a subpoena to a local branch of Chase or Bank of America was enough to freeze a marital estate. In 2026, a sophisticated spouse might not be hiding cash in a Cayman Islands offshore account. They are likely hiding it in plain sight within decentralized finance protocols, non-fungible tokens, and virtual real estate. This is the era of the cyber-matrimonial litigator. Imagine a high-stakes scenario involving a couple we will call Ethan and Sophia. Ethan is a software engineer who began investing in early-stage cryptocurrency back in 2015. During the marriage, he moved those assets through a series of privacy-focused mixers and eventually into a decentralized autonomous organization, or a DAO. When Sophia files for divorce in 2026, Ethan provides bank statements showing a modest savings account and a standard salary. To the untrained eye of a traditional 1990s-style lawyer, Ethan looks like an average middle-class professional. However, a modern divorce lawyer, trained in blockchain forensics, begins by looking for the digital fingerprints that Ethan left behind. Step 1 in this digital hunt is the forensic imaging of all devices. The lawyer files an emergency motion to seize and clone Ethan's laptops, tablets, and smartphones. They aren't just looking for emails. They are looking for browser history related to crypto exchanges, seed phrases hidden in Notes apps, and the presence of cold storage wallet software like Ledger or Trezor. Even if Ethan has deleted the apps, the forensic analyst can find remnants of the installation files. Once a single public wallet address is identified, the lawyer uses specialized tools to map out the entire history of that wallet. The blockchain is a public ledger, which means while it is anonymous, it is also perfectly transparent. If Ethan transferred $500,000 worth of Ethereum to an unknown address 3 months before the divorce filing, the lawyer can track that money as it moves through various liquidity pools. The strategy here is not just to find the money, but to establish a historical trend of waste or dissipation of marital assets. If the lawyer can prove Ethan intentionally moved marital funds into a private digital vault to hide them from the court, the judge can award Sophia a greater share of the remaining tangible assets, like the family home or Ethan's retirement account, to offset the hidden digital wealth. But the complexity deepens when we enter the metaverse. In 2026, virtual real estate in platforms like Decentraland or The Sandbox can be valued in the millions of dollars. Imagine if Ethan purchased a prime piece of virtual land next to a major digital brand's headquarters during the marriage. This land generates revenue through virtual billboards and digital storefronts. To a traditional judge, this looks like a video game. To a modern divorce lawyer, this is a commercial real estate asset. The lawyer must hire virtual appraisers who understand the volatility of the digital land market. They must argue that the appreciation of this virtual plot, bought with marital earnings, is community property. This leads to the fascinating case study of the NFT as a marital asset. During the boom of digital art, many couples invested heavily in high-value NFTs. In 2026, the market for these assets is highly illiquid. If a couple owns an NFT that was valued at $200,000 last year, but hasn't had a recorded sale in 6 months, how do you divide it? The lawyer might propose a constructive trust, where the asset remains in a joint digital wallet, and the proceeds are split only when the asset is eventually sold. Alternatively, they might engage in a digital buyout, where one spouse keeps the NFT in exchange for giving up a larger portion of the liquid cash in the bank. Step by step, the modern divorce lawyer is also dealing with the rise of the smart contract divorce. We are seeing historical trends where wealthy individuals are attempting to use self-executing code to bypass the family court entirely. They write prenuptial agreements into smart contracts that automatically transfer digital assets to specific wallets the moment a divorce is filed in the public record. The lawyer's job is now to challenge the legality of these automated transfers. They argue that a computer program cannot account for the equitable distribution laws of a state like California or New York. The courtroom battle is no longer just about the law of the land. It is about whether the law of the code can override the sovereignty of the court. Another layer of this digital warfare is the use of deepfake technology in custody and fault-based disputes. While most states are no fault, evidence of parental unfitness still heavily influences custody arrangements. In 2026, a disgruntled spouse might use generative AI to create a realistic, but entirely fabricated video of their ex-partner, engaging in substance abuse, or making disparaging remarks about their children. The divorce lawyer has had to become a gatekeeper of digital authenticity. They must hire AI forensic experts to analyze the metadata and the lighting inconsistencies in video evidence to prove it was manufactured. This has added tens of thousands of dollars to the cost of a high-conflict divorce, as every piece of digital evidence is now viewed with extreme skepticism. Furthermore, the lawyer in 2026 is dealing with the concept of the digital legacy. If a spouse dies during a protracted divorce proceeding, who owns the passwords to the family's cloud storage? Who owns the rights to the deceased spouse's digital likeness or their social media archives? Lawyers are now drafting specific clauses into separation agreements that treat digital access as a fundamental right, akin to visitation. They are negotiating over who gets the primary login for the family's Amazon account or the historical archives of the children's photos stored in a shared Google Drive. What we are seeing is the final collapse of the wall between the physical and the digital in the eyes of the law. The divorce lawyer of a century ago would be baffled by a legal dispute over the ownership of a virtual sword or a decentralized autonomous organization. But the core human motivations remain identical: greed, fear, and the desire for leverage. The tools have simply become more abstract. However, just as the lawyers were mastering the blockchain, a new and even more pervasive force began to take over the entire legal industry. It wasn't just about where the money was, it was about who was actually making the decisions. The rise of artificial intelligence was no longer just a tool for the lawyers. It was starting to replace the lawyers themselves, leading to a world where a divorce could be settled by an algorithm before a human ever stepped into a law office. This shift promised efficiency, but it hid a much darker potential outcome for the future of human empathy in the justice system. The transition from the human-driven, emotionally charged battles of the 20th century to the cold, data-driven automation of 2026 represents the most significant structural change in the history of American family law. For nearly 90 years, the divorce lawyer was viewed as a necessary, albeit expensive, human intermediary. They were the counselors who sat across from a distraught client, handed them a tissue, and navigated the messy nuances of human resentment. But as the cost of a traditional contested divorce in the United States reached a staggering average of $15,000 to $30,000 per person, the market hit a breaking point. The legal industry responded by creating what is now known as the algorithmic arbitrator. The rise of AI in family law did not happen overnight. Historical trends show a steady progression from simple online form fillers in the early 2010s to the sophisticated, predictive settlement platforms we see today. In 2026, many middle-class couples are completely bypassing traditional law firms in favor of unbundled legal services powered by large language models and predictive analytics. The lawyer is no longer the architect of the strategy. The lawyer is increasingly becoming a data auditor who simply signs off on what the machine has already calculated. Imagine a case study involving a couple in 2026 named James and Isabella. They have been married for 12 years, own a home in a Denver suburb, and have 2 children. They are not ultra-wealthy, but they have a complex web of modern assets: a joint Vanguard account, 2 different employer-sponsored 401ks, a small collection of digital collectibles, and significant student loan debt. In 1996, James and Isabella would have each paid a $5,000 retainer to separate attorneys who would have spent 6 months arguing over the equity in the house. In 2026, they log into a platform that uses a proprietary algorithm to ingest their last 5 years of financial data directly from their banking APIs. The step-by-step process of this automated dissolution is terrifyingly efficient. Step 1 is the data ingestion phase. The AI does not ask them to list their assets. It simply watches their money. It identifies recurring payments, detects hidden accounts through transfer patterns, and categorizes every expense. Step 2 is the normative comparison. The algorithm compares James and Isabella's financial profile against thousands of historical case studies from their specific judicial district. It knows exactly how Judge Miller on the 3rd floor usually divides a 401k when one spouse has a higher earning potential, but the other carries the majority of the childcare burden. Step 3 is the predictive settlement proposal. Instead of a lawyer making a highball opening offer, the AI presents a 3-tier settlement plan based on potential outcomes. It shows them a 50-50 split, a 60-40 split, and a customized split that maximizes tax efficiency for both parties. The psychological shift here is profound. When a human lawyer tells you that you deserve 60% of the house, it feels like a battle of wills. When an algorithm shows you a heat map of 5,000 similar cases and tells you that you have a 92% statistical probability of losing in court if you ask for more than 55%, the incentive to fight vanishes. The AI uses the threat of mathematical certainty to force a settlement. This leads us to the concept of AI-driven discovery. In the previous decades, paralegals would spend weeks manually reviewing thousands of text messages and emails to find evidence of hidden assets or parental unfitness. In 2026, this process takes seconds. A divorce lawyer now uses specialized AI agents that can perform a sentiment analysis on 10 years of a couple's digital communication. These tools can flag every instance of aggressive language, every mention of a secret purchase, and every contradiction in a spouse's narrative. The lawyer is no longer looking for a needle in a haystack. The AI is handing them a magnet that has already pulled the needle out. However, the potential outcomes of this automation are not entirely positive. We are seeing a significant historical trend toward the loss of judicial discretion. In the 20th century, a judge could look at a mother or father and sense a nuance that wasn't on the paper. They could exercise mercy or adjust a ruling based on the unique, intangible human elements of a family's history. But as lawyers and clients rely more on predictive algorithms to settle cases before they ever reach a judge, the law is becoming increasingly rigid. If the algorithm says the average child support payment for a certain income bracket is $1,200, that becomes the de facto law, regardless of whether a child has special needs that the dataset failed to properly weight. Furthermore, the role of the attorney as a counselor is being systematically erased. The phrase attorney and counselor at law used to mean something. It meant the lawyer was there to manage the human fallout. In 2026, the competitive pressure to lower costs has forced many firms to strip away the counseling aspect entirely. They are now legal tech factories. The client interaction is handled by chatbots, and the strategy is dictated by data visualizations. This creates a high-retention environment for the law firm's profit margins, but it leaves the human beings in the middle of the divorce feeling like cogs in a machine. Consider the scenario where the AI detects an anomaly in Isabella's spending. It flags a series of small, frequent payments to a therapist and a moving company 3 months before the divorce was filed. The AI suggests to James's legal team that Isabella was planning the separation in advance and may have been siphoning marital funds into a private account. In the hands of a human lawyer, this might be a point of negotiation. In the hands of an automated system, it becomes an immediate, non-negotiable deduction from her share of the estate. There is no room for her to explain that she was seeking therapy for domestic issues the AI cannot quantify. The data has no empathy. This technological surge has also birthed a new breed of legal professional, the family law data scientist. These are individuals with law degrees who spend their days fine-tuning the weights and biases of the settlement algorithms. They are the ones who decide how much weight the AI should give to a spouse's career sacrifice versus their direct financial contribution. These decisions, once made in open courtrooms subject to public scrutiny and the rules of evidence, are now made in the private code of tech startups. The divorce lawyer is no longer just a master of the statutes. They are a gatekeeper of the black box. What happens to the children in this automated world? We are seeing the rise of algorithmic parenting plans. Instead of a customized schedule built around the family's unique rhythms, AI generates a statistically optimized calendar designed to minimize parental conflict and maximize transit efficiency. It sounds perfect on a spreadsheet, but it fails to account for the emotional reality of a child who just wants to stay an extra night with a parent because they are feeling sad. The lawyers of 2026 are finding that while they can automate the division of the bank account, they cannot automate the healing of the family unit. But as the legal industry continues to lean into this high-speed, low-touch model, a massive backlash is beginning to form. While the middle class is being pushed toward the algorithm, the ultra-wealthy are doing the exact opposite. They are moving back toward the most traditional, human-centric, and intensely private forms of lawyering imaginable. There is a growing divide between the digital justice for the masses and the bespoke, artisan justice for the elite. And as this gap widens, the very definition of what it means to be a lawyer is being torn apart. The final evolution of the divorce lawyer isn't just about robots replacing humans. It's about a return to a form of legal warfare so ancient and so powerful that it makes the high-tech tools of 2026 look like toys. The next part of our dive explores how the most successful lawyers are now using the one thing an AI can never replicate: the power of the narrative. This narrative pivot is rooted in a fundamental truth of human psychology that even the most advanced neural networks of 2026 cannot fully simulate. the fact that humans do not make decisions based on data alone. They make decisions based on the stories they tell themselves about that data. While the algorithmic tools we discussed are excellent at calculating the equitable distribution of a retirement account, they are utterly incapable of navigating the ego, the pride, and the deep-seated desire for vindication that drives high-stakes litigation. The elite divorce lawyer of 2026 has recognized this limitation and rebranded themselves as a narrative architect. They have moved away from being mere legal practitioners and have become directors of a carefully curated reality. This is the era of the bespoke legal strategist, where the goal is not to win an argument in front of a judge, but to win the psychological war before a single motion is even filed. Imagine a high-profile case study in the current year 2026. We have a couple, Alexander and Victoria. Alexander is a beloved public figure, perhaps a high-ranking political consultant or a tech visionary, and Victoria is a successful venture capitalist. Their public image is a cornerstone of their respective net worths. In this tier of society, a standard divorce filing is a strategic liability. If the data-driven AI systems were to handle their split, the resulting public record would be a dry, clinical autopsy of their failures. Instead, they hire artisan lawyers who specialize in narrative integration. Step 1 in this sophisticated process is the assembly of a multidisciplinary war room. The lawyer no longer sits alone at the head of the table. Flanking them are crisis communication experts, reputation management consultants, and even behavioral psychologists. The first objective is not to count the money, but to define the narrative of why the marriage ended. Historical trends in the 2020s show that the most successful potential outcomes for high-profile figures involve a narrative of conscious evolution. The lawyers work with PR firms to draft a joint statement that is released simultaneously across all digital platforms, framing the dissolution not as a failure, but as a strategic partnership transition. This is narrative building as a shield. By controlling the first strike of information, the lawyer prevents the opposing side, or the tabloids, from filling the vacuum with a more damaging story. Step by step, the lawyer then executes the narrative anchor strategy. This involves identifying a single, emotionally resonant point of leverage that has nothing to do with the law and everything to do with the opponent's identity. For example, if Alexander's lawyer knows that Alexander's greatest fear is being perceived as a neglectful father by his professional peers, the lawyer will not lead with financial demands. They will lead with a narrative centered on parental legacy. They will propose a custody arrangement that is visually and socially optimized for Alexander's public life, effectively trading financial concessions for the preservation of his ego. The lawyer is playing a game of psychological chess, using the narrative as the board. This leads us to the explosive growth of collaborative law in 2026. While it originated in the late 20th century as a way to reduce conflict, it has morphed into the ultimate gatekeeping tool for the elite. In a collaborative divorce, both parties and their lawyers sign a binding contract that stipulates if the case ever goes to a public courtroom, both sets of lawyers must immediately resign and be disqualified from further representation. This creates a powerful financial and strategic incentive to stay in the room and settle. It essentially creates a private, high-stakes vacuum where the only thing that matters is the negotiation between the four people at the table. The historical trend here is a move away from the adversarial bomber lawyer and toward the diplomatic closer. In these collaborative sessions, the lawyer's primary skill is not cross-examination, but facilitated empathy. They use a technique known as interest-based negotiation. Instead of arguing over who gets the $10 million vacation home in Aspen, a positional battle, the lawyer digs for the underlying interest. Does Victoria want the house because she wants the equity, or because it's the only place where she feels her children are safe from the paparazzi? If the lawyer can identify the narrative interest, they can craft a solution that an algorithm would never suggest, such as a long-term leaseback agreement or a specialized trust that keeps the property in the family legacy without triggering a taxable sale. Furthermore, the artisan lawyer of 2026 utilizes the concept of shadow discovery. While the middle class is subject to the invasive AI-driven digital audits we discussed previously, the elite lawyer uses a much more subtle form of intelligence gathering. They employ forensic behavioral analysts who study the opposing spouse's social media feeds, public appearances, and even their philanthropic choice to build a psychological profile. They are looking for the weak points in the narrative. If Victoria is publicly advocating for women's financial empowerment, while privately attempting to hide assets from the marital estate, the lawyer doesn't just file a motion. They present this contradiction to Victoria's legal team in a private, high-pressure mediation session. The threat is not the court's judgment, The threat is the destruction of her carefully crafted public narrative. This approach requires an incredible amount of human intuition, something that remains the final frontier of legal practice. An AI can analyze 10,000 transcripts of Judge Henderson's previous rulings and tell you he is likely to award alimony. But an artisan lawyer can sit in a room with Judge Henderson, notice the slight hesitation in his voice when a certain topic is mentioned, and pivot their narrative in real time to align with the judge's unspoken values. This is the art of reading the room, a skill that commands fees of $2,000 an hour in 2026. Case studies of these narrative-driven settlements often reveal that the final dollar amounts are actually less important to the clients than the terms of the narrative. In 2026, we see more settlements where a spouse will walk away with $20 million less than they are legally entitled to, provided they get a global non-disparagement agreement and a public narrative that preserves their professional reputation. The lawyer has become a dealer in the currency of status. However, this reliance on high-level narrative and shadow justice creates a profound ethical vacuum. When the law is treated as a malleable story told in private rooms, what happens to the concept of objective justice? The American divorce lawyer has spent a century moving from the rigid moralism of the 1920s to the clinical math of the 1970s, and finally to the curated simulations of 2026. We have reached a point where the truth of a marriage is secondary to the utility of the story told about its ending. As we reach the conclusion of this century-long deep dive, we have to look at the final, most haunting transformation of the profession. We have seen the lawyer as a fixer, a bomber, a financial bloodhound, a cyber detective, and a narrative architect. But as the gap between the algorithmic justice of the masses and the artisan justice of the elite becomes a canyon, the very foundations of the American legal system are beginning to shake. The final part of our journey will reveal the ultimate destination of the divorce industry, a future where the lawyer may no longer be defending a client, but presiding over a society where the traditional family unit has been completely redefined by the very legal tools meant to protect it. What remains when the century of practice finally ends? We are about to see the endgame of the most controversial profession in American history. The endgame of the American divorce lawyer is not the disappearance of the profession, but its total integration into the fabric of daily life through a concept known as the perpetual legal marriage. We are witnessing a historical trend where the boundary between being married and being divorced is becoming a transparent, shifting digital threshold. In the year 2026, the elite lawyer has moved beyond the one-time event of a divorce and into a lifetime model of matrimonial risk management. This final evolution represents the ultimate commodification of human intimacy, where the legal professional acts as a permanent chief operating officer for the family unit. Imagine a scenario playing out right now in 2026 involving a couple named Benjamin and Maya. Benjamin is a high-level biological researcher, and Maya is a prominent digital estate curator. When they married 5 years ago, their attorneys did not just draft a standard prenuptial agreement. They constructed a dynamic marital operating agreement, or a DMOA. This is a living legal document that exists on a private blockchain, updated in real time by AI agents that track the couple's income, asset acquisition, and even their shared parenting hours. In this 2026 model, the divorce lawyer's primary role is the continuous adjustment of this contract. Every time Benjamin receives a patent or Maya's digital archive increases in valuation, the lawyer executes a step-by-step rebalancing of the marital equity. This leads to the rise of the post-decree continuity manager. In the 20th century, the lawyer's job ended when the judge signed the final decree. In 2026, the signing of the decree is merely the beginning of a 20-year service contract. Because modern marital estates are so heavily tied to ongoing digital royalties, unvested crypto assets, and complex co-parenting schedules, the legal fees have transitioned into a subscription model. The attorney remains on a monthly retainer to manage the logistical fallout of the separation indefinitely. If the AI detects a misparenting transition or an unauthorized withdrawal from a joint trust, the lawyer's office is automatically alerted to intervene. The historical trend has moved from litigation to a state of permanent, high-tech supervision. We must also examine the step-by-step emergence of the multi-parent legal framework. As of 2026, the American divorce lawyer is increasingly litigating the rights of non-traditional family structures. We are seeing a massive spike in cases involving 3 or more legal parents, often in situations involving surrogacy, egg donation, or intentional polyamorous family units. The lawyer's task is to deconstruct a legal system built for a binary pair and forge a new path for tripartite custody and support. This involves the creation of complex parenting trusts where 5 or 6 different individuals might have varying levels of legal standing. The potential outcomes of these cases are currently being decided in appellate courts, as attorneys argue that the best interests of the child must evolve to recognize social and biological contributions equally. Furthermore, the 2026 divorce lawyer is navigating the rise of corporate sovereignty within the home. To avoid the unpredictable nature of state family courts, many high-net-worth couples are now advised by their legal teams to structure their marriage as a private limited liability company. Under this model, the spouses are not just husband and wife. They are minority and majority shareholders in a corporate entity that owns the house, the cars, and the bank accounts. When the marriage ends, the lawyer does not file for divorce in a family court. They file for a corporate dissolution in a commercial chancery court. This allows them to bypass traditional alimony statutes and equitable distribution rules, replacing them with the cold, predictable logic of contract law and shareholder rights. This is the ultimate strategic maneuver, turning the most intimate human bond into a strictly commercial transaction to protect the wealth of the elite. Consider the potential outcomes of this shift for the American public. While the elite can afford this bespoke corporate shielding, the average citizen is left navigating an increasingly automated public system. We are seeing a case study in the polarization of justice. In 2026, a lawyer for a middle-class client might use a settlement bot to finalize a divorce in 3 days, while a lawyer for a billionaire spends 3 years in a private, high-security boardroom litigating the valuation of a proprietary AI algorithm developed during the marriage. The profession has split into 2 entirely different worlds, one that is purely mechanical and one that is purely strategic. But there is a darker, more complex layer to this endgame: the social credit of divorce. In 2026, an individual's legal history, including the details of their divorce and custody battles, is increasingly integrated into their digital reputation score. Aggressive litigators are now using this as a tool for extortion. A lawyer might inform an opposing spouse that if they do not agree to a specific financial settlement, the lawyer will ensure the public record reflects a narrative of emotional volatility or financial instability that will tank the spouse's digital credibility, making it impossible for them to secure future loans or high-level employment. The lawyer has become a digital executioner, using the permanent record of the court to destroy a person's future viability in the 2026 economy. The historical trend over the last century shows a steady move away from the idea of the lawyer as a seeker of truth and toward the lawyer as a master of leverage. From the 1920s hotel raids where they manufactured adultery, to the 1980s where they weaponized child custody, to the 2026 era of algorithmic warfare and digital reputation destruction, the goal has remained consistent: the extraction of the maximum possible value from the wreckage of a human relationship. The divorce lawyer is the only professional who consistently profits from the total collapse of the most fundamental unit of society. As we conclude this deep dive into the century of practice, we have to recognize that the American divorce lawyer is not just a participant in the system. They are its lead architect. They have lobbied for the laws, invented the tactics, and built the multi-billion-dollar infrastructure that ensures their own necessity. Whether it is through the cold efficiency of AI or the expensive theater of private arbitration, the industry has successfully transformed the end of love into a permanent, highly profitable legal industry. What remains when the century of practice finally ends? We are left with a legal landscape where the human element is being systematically stripped away, replaced by data points, corporate structures, and permanent surveillance. The divorce lawyer has successfully decoupled the dissolution of a marriage from the concepts of justice and morality, replacing them with a framework of efficiency and asset protection. But as we move into the late 2020s, a new question is beginning to emerge in the legal community. If the lawyer has become so successful at automating and corporatizing the end of the family, what happens to the concept of the family itself? We are standing on the precipice of a future where the legal tools created to manage the end of a marriage are beginning to redefine how we enter into them in the first place, leading to a world where every human connection is pre-litigated, pre-calculated, and pre-liquidated. The history of the divorce lawyer in America is far from over. It is simply entering its most radical and unrecognizable phase, where the law of the contract finally and fully replaces the law of the heart. This century of strategic evolution has led us to a terrifying question that the legal industry is not yet prepared to answer. In a world where every ending is optimized for profit and data, is there any room left for the messy, unpredictable, and ultimately human process of moving on? The tactics have been perfected, the tools have been sharpened, And the stage is set for a future where the lawyer is the most powerful person in every room, from the wedding chapel to the courtroom. But as the algorithms take over and the private judges close their doors, we must ask if we have built a system that is so efficient at ending things that it has forgotten how to let anything truly begin. The next great shift in American law won't be about how we divorce. It will be about whether the legal industry has made the traditional concept of marriage entirely obsolete in the face of its own relentless innovation.